board system was a
I don't want them. Like email and service.
এই ইমেলও একটা সার্ভিস হয়েছে, ইমেলের সার্ভিস না হার্ড কপিও দেওয়া আছে।
Yes.
Now if you look to page 25, this is the scheme framed by
Just get hold of the name of the learned advocate who is appearing for the state. Inquire from the GP's office. Yes.
Now this is child care leave.
All right, child care leave. Paternity child care leave.
Yes. And this is not maternity leave or paternity leave. This is child care leave.
All right.
Now first paragraph, the matter regarding extension of benefit of child care leave for
which page are you reading?
Page 25.
Yes.
This benefit was considered by the authorities and was extended to all school board, district primary school council, school commission, service commission, as well as to the regular female employees of the Panchayat Raj and other local bodies, undertaking corporations, statutory bodies, etc. This benefit was given only to the
female teachers.
Now, after careful consideration, the government is pleased to extend the said benefit to the regular female employees. Here, I join issue of the education institution, establishment, organization, etc. on the following terms and conditions. Other benefits which is available, that is paternity cum child care leave at page 27. This is for the male employees.
Yes.
Yes. This is 2016 introduction of paternity cum child care leave to the male state government employees and such employees of the Panchayat Raj and other local bodies, board sponsored non-government aided schools, etc. Now, after careful consideration of the matter, the government has been pleased to decide all male state government employees as well as the employees of the bodies and boards, education institution, etc. with less than 2 surviving children will be allowed paternity cum child care leave for 30 days. And therefore, this is paternity leave for 30 days. Now, if you kindly look to page 33. This is of the union government. Page 33.
Yes.
This amendment to the service rules of the central government employees was introduced in the year 2018 in the middle in rule 43C. Have you got it?
Yes.
Sub-rule 1 following sub-rule shall be substituted, namely, subject to the provisions of this rule, a female government servant and the single male government servants may be granted child care leave by the authority competent to grant leave for a maximum period of 730 days during entire service for taking care of 2 eldest surviving children, whether for rearing or for looking after any of their needs, such as education, sickness, and like. And then 3. Grant of child care leave to female government servants and single male government servant. Under subsection 1 shall be subject to the following condition. The condition has been stated. Then clause 4. During the period of child care leave, female government servant and a single male government servant shall be paid 100% of the salary for the first 365 days, at 80% salary for the next 365 days. Single male government servant means unmarried, widow or divorced government servant. So this benefit has been to some extent extended to the central government employees. So far male widower is concerned. So far our scheme is concerned, which is prevailing in our state. To me, this is absolutely discriminatory. That our constitution directed to ensure gender neutral legislation. Now this legislation has been made following the principle as ancient directive principle of state policy in Article 45 and 47 of the Constitution. Following that, this principle was introduced. Now, if you look to the other provisions of the this is Juvenile Justice, Child Care and Protection of Children Act 2015. They are also the definition of guardian has been mentioned. Who was the guardian? Here, the definition of guardian does not distinguish between father and mother. Now, to me, making provision for the child care only for woman or female, that indicates that we are still preaching the patriarchal society, where we have decided that it is the obligation of the female to look after their children and not the male.
You have page 27 over here.
I have 47.
27.
27,
page
yes.
27 is there. Paternity leave is granted.
But this is for 30 days.
You want extension of time?
Most certainly, because this cannot be discriminatory. It is the provision.
State government in page 25 for the female employees have given how many?
730 days.
730 days.
It is the mother and the father, they will decide who is to take care. It is not the obligation of the mother to take care of his child. That is my submission.
So 730 days and yours is 30 days only.
This child care should be equally distributed. That is my submission.
Very well. State, is anybody else?
But here, Lordship, center.
Are you there for the state?
I am for the state, Lordship.
Council is also there, not 24 parties.
No, I am not. Council is not necessary party. I am appear, but the council is not necessary.
All right, then it's all.
Here, Lordship, the center government law notification, Lord. I am not adopted the there, Lordship, 7 days. It is a total of the finance department. My learned friend, two options is here, Lord. We made a representation before the finance department or consider all, Lordship, if the director to a file, Lordship, affidavit opposite.
No, affidavit will not serve purpose. It is a policy decision of the state government.
I ask for
Right. Now it is you who can change your policy.
I am not.
The court is not directing you to do it.
That my submission.
Right. Now, according to the petitioner, there is 730 days of regular female employees leave.
Female I understand.
Now this person, he is a single parent. Why will this benefit not be extended to him?
If the Lordship finance department not adopted by the central government.
No, forget the central government.
But Lordship, as per my instruction, Lordship, I am not adopted, Lordship, that 730 days.
Forget there is a scheme for the central government. The state government has a scheme for the female employees.
Not for the male.
Not for the male. Why will the same benefit not be extended to the males who are single? They may be widower, they may be divorcee, or a single parent. Why can it not be? Take a decision.
But the decision is to give the Lordship. Lordship made a representation before the
representation must be his own personal case. He will not go in for this is not a.
Otherwise, Lordship, I am taking a decision, Lordship. I am not Lordship. Here, Lordship, I adopted or not. Here, Lordship, page 37 is here, Lordship.
Please come.
Only one more thing, this issue has come up before this honorable court previously, in a matter where the approval was not given despite there is application by a female employee. Now court has considered the entire object and made certain observation. And it may have certain help. I am on it was the scan was not perfectly done. It was uploaded. And in any event, if you just kindly takes up
yes,
page 4, last paragraph. The sentence starts with in other words, while the society provides guarantee of equality, it does not provide the means for a woman to be something and still earn our livelihood. Instead, it is expected that
the left portion has cut off.
yes, Vlad. The only thing that if it kindly takes up the paragraph, it starts with as I analyzed. The very next page, as I analyzed the very introduction of the concept of granting childcare leave to a mother by a democratic state, considering not just the health and the nutritional welfare, but even the development needs of a child, which includes inter alia the emotional, physical, and mental nourishment from the parents. I find that even if the relief is granted to the mother, the very framework is predisposed to perpetuate the existing notions of patriarchy, which has still not been dispelled despite 68 years of constitutional experiment in our country. It is noteworthy that the conception of a family arises out of equal contribution from both parents, and the outcome must therefore not be treated as a liability of the mother or the father alone, where the situation is not a single parent. Sadly, the legal framework addressing the concerns like child welfare does not concentrate on this aspect of the family life, but is rather based upon what seems to be a social assumption. As I proceed to address this notion, I observe that even though the fundamental principles of equality enshrined under Part 3 of the Constitution of the India prefer gender neutrality, in situation like this, the said concept is absent. That apart, it is to be seen whether when there is a conferment of an affirmative right on woman, it can go to that extent of treating them as a sole bearer of the child care in all circumstances, even at the cost of their professional distress. Viewed from this vantage point, such provision seems to create a dent in the individual independent identity of a woman and tantamounts to subordination of a woman where the constitution confers equal status. A time has come when society must realize that a woman is equal to a man in every field. Presumption that the responsibilities within the family must be the priority of the woman appears to be quite anarchic. When society progress and rights are conferred, a new generation of rights springs forth, which under the existing circumstances are indispensable to the growing movement.
Very well, I have got it.
This is observation made in that matter, Black.
This is a very good issue for moving a pill, right? But since you have
It's a child service matter.
you have an independent application, let them consider at least. Please come.
Lordship, may leave has been granted by junior teacher.
Yes, yes. The petitioner is a teacher in a primary school.
No.
He has 2 minor children. Stop. His wife passed away a couple of months back. Stop. His children are presently school going. And there is none to take care of his children apart from the petitioner. Stop. For taking care of his children and for their physical and emotional development, he intends to take the benefit of the child care leave. Paragraph. According to the memorandum number 1100-F within bracket P, dated 25th of February 2016, the government of West Bengal introduced the paternity cum child care leave for 30 days to the male employees. Stop. The petitioner contends that 30 days will not be enough for him to take care of his children. Stop. He refers to the memorandum number 5560-F within bracket P dated 17th July 2015, where a maximum period of 2 years, that is 730 days, the benefit of child care leave has been extended to the regular female employees. Stop. It has been submitted that right now, the petitioner is a widower and a single parent. The benefit of 730 days child care leave ought to be extended to him. Stop. Paragraph. It has been submitted that the aforesaid two memoranda are
discriminatory and gender bias.
They are discriminatory. Stop. When the Constitution speaks of equality, the state government should rise to the occasion and should encourage equality in all respects. Stop. Paragraph. It should not be the idea of the women taking care of the children should not be encouraged. Stop. Both parents should be responsible for taking care and for development of their children. Stop. Next. Reference has been made to the Act where guardian has been described to include both the male and the female parent. Yes, both the mother and the father. Just give the name.
The Juvenile Justice Care and Protection of Children Act 2015.
The Juvenile Justice Care and Protection Act 2015.
Protection of Children Act 2015.
Protection of Children Act 2015. Stop. Reference has also been made to the order passed by a coordinate bench of this court on 13th of November 2018 in WP 9776 W of 2018 within bracket Srimati Shikha Sarkar versus the State of West Bengal and others. Stop. Next. The petitioner also relies upon the notification, not relies, but refers to the notification of the Ministry of Personnel, Public Grievances and Pensions within bracket